Rebuttal argument?
Mr. McCann and I have agreed that I am allowed to make the following statement with his approval in order to correct perhaps a misstatement. That after the SS incident, Mr. Dahmer was sentenced to 8 years in prison. It was stayed. He was placed on probation for a period of 5 years, the first year of which was to be served in the House of Correction under the Huber Law, and he did the period of time that has been agreed upon, and I think it's necessary for me to correct that in case there's a misperception as to the type of sentence that the judge imposed.
Mr. Boyle, whenever I use Huber law in relation to a disposition like that, I am always corrected. It is work release.
Work release. Thanks, Judge. Well, it's been many years since I have had the last word in a jury trial. Years ago, when I was in the DA's office and served with our very fine district attorney, the district attorney always had the last word, and it was a great advantage. It is not a great advantage in this case because of the gravity of the situation. You know, Mr. McCann complimented me, and I am confident there is nothing that I can say that is in any way going to alter what you people feel the evidence is. My job is to assist you. Believe it or not, I don't want you to forget these young men that died. The opposite's true. I stand here representing a man who's admitted to those killings and pled guilty to them. This is not a murder case. This is whether or not, at the time of the commission of the offenses, not if he was out of control, but whether or not, because of his mental illness, he was able to conform his conduct to requirements of law. The world, the state, the nation is watching this courtroom because of the interest of this case. I think it remarkable that we live in a country where we can be here talking about these things. There are a few times in my life when I take great pride in things that I do, but this is one of them because it separates us, as I said in my opening part, from any other country in the world. I remember during the Gulf War how proud I was to be an American when everybody's so fearful of what was going to happen there, and the Republican Guard and the vaunted Republican Guard, and we heard all that propaganda. And that ended like that. And I can remember that American soldier welcoming the Republican Guard fellows out of their foxhole and saying, "Come on, fella, it's going to be okay. Nobody's going to hurt you." I had more pride in watching that because that's what it is to be an American. And what it is to be American in this case is the fact that I can stand before you not trying to get somebody off of anything, but I can stand before you to find out whether or not these men died because of a maniac killer or whether they died because the guy was sick. And that's what justice is. Not trying to fool you. I couldn't fool you if I talked for 1,000 days. But rebuttal, really, the fairness of rebuttal is to get up and say, here's what you said, Mr. McCann, and here's where I got to disagree with you. And it's not like the opening part of the statement where I don't need the notes. I have to look at things, and I don't like doing that. All I've been hearing about is how his guys are tougher than my guys. The guys on his block can beat up the guys in my block. That's not true. It's just not true. That's not the way we play the game. Is there something about these forensic psychiatrists that makes them so wonderful that they know everything? Let me ask you this. Here's a forensic psychiatrist who spends lots of time with Jeffrey Dahmer. Here's what he said. He said, "I think the guy was mentally diseased because I think he was suffering from a paraphilia, not otherwise specified, which I call necrophilia. I believe he had alcohol dependence and it was mild. And on axis 2, I think he had a schizotypical personality disorder and a borderline personality disorder. And then I have another doctor, a forensic psychiatrist, great doctor, and he says, this fella was suffering from a paraphilia, not otherwise specified. Frauderism, that is brushing against people without their consent. Partialism, because with the dead bodies he did something with parts of the bodies. And necrophilia. And his alcohol was mild to moderate. He had an alcohol dependence, mild to moderate. And he also says, and another thing he had on the axis too, was he had schizotypical traits. That's really different, isn't it? The one doctor, the first one, said, and I also think he had a psychotic disorder, not otherwise specified, because I think his doing the business with the eating and the temple and all of that, I think put him in that category also. And you know who they were? They were the rookie and the Hall of Famer. They were Wallstrom and Dietz. You know how much and how far they're separated from each other? A hair. A hair. Let me tell you something else. This Dr. Wallstrom, you know, I don't think in a court of law what we do is we bring in professional actors. Nobody's done that in this case. In the court of law, we bring in somebody to educate a jury. Dr. Wallstrom has his personality. Dr. Dietz has his personality. When I talked to Dr. Wallstrom, he looked at me. When Mr. McCann talked to Dr. Dietz, he looked at you. Nothing wrong with that. That's the way he does it. He's a forensic psychiatrist. His living is made by coming in and testifying, or part of it. That's inherent in what he does. Wallstrom's new at it. He's just starting into that. But you know what's really interesting? Wallstrom's been out of school a year. One of the biggest events in the 20th century was the attempted assassination of the President of the United States of America. Dr. Dietz testified in that case. He led the team. He was the main man. He was 3 years out of his residency training. 81, he was hired. He had graduated out of his residency training. 78, that's 3 years. How dare he do that? Fact of the matter is, you know what his opinion was in that case, and you know whether it was accepted or rejected. But so what? I wouldn't have criticized Dr. Dietz because he was only 3 years any more than I'd criticize Dr. Wallstrom because he was a year. And when you look at what both of them said in this case, they're a hair apart. It's that one said, I think all this temple business and this eating business and all this other business kind of puts this guy into a schizo deal. I've got to say that to you, ladies and gentlemen of the jury. My other two doctors said, I considered those things, but I didn't go to the step of saying that I could show it to a reasonable degree of psychiatric certainty. And I am offended, literally offended, that only Dr. Dietz did the complete job. Where has it been stated in this record that my doctors did not look at Exorcist 3 and Return of the Jedi? I never asked the question because I didn't think it was all that big a deal, and it wasn't asked in cross-examination. But don't be fooled that they didn't, because the question wasn't asked and answered. And because it was asked and answered with Dr. Dietz, who was sitting there with Mr. Dahmer and decide that's one of the things he wants to do, doesn't mean my doctors didn't do their job. And this business about, I asked him about his alcohol. You know, I asked him about his alcohol because I couldn't understand how a doctor with all of the things that he has in his bag could write down that it was mild to moderate. God, I would have thought he would have put down raving alcoholic with all this drinking. And I wanted you to hear about his drinking history. But it isn't like, well, he's the only one who had it, because I'm going to tell you something. Dr. Becker read her entire report in here, and I tell you something. She's got his drinking from the time he had his first drink when he was in high school, through the Army, thereafter, how many jobs he lost because of drinking, how much he drank, why he had to leave Bath, Ohio when he came back because he was drinking too much. Dr. Dietz isn't the only one that uncovered that. The only reason we went into that alcohol thing at all was I wanted to find out how much alcohol was responsible, and they all said that if he didn't drink, we still would be standing here today. Alcohol was not the primary movement. It was something that he had but they all say he was a necrophiliac or a paraphiliac. That's simple. So I have to say to you, ladies and gentlemen of the jury, the following. When I asked Dr. Dietz, do you agree with Dr. Resnick, who is a national authority on necrophilia, that it is a very rarely and poorly understood phenomenon? He said yes. When I asked him if he agrees with the doctor, when it's quoted in that same article, that alcohol plays a part in these necrophiliac acts because a person with necrophilia finds that it lowers his inhibitions, he said, yes, I agree with that. And when I asked although the most common motive for necrophilia was the possession of an unresisting, unrejected partner, the necrophiles frequently express more than one motive for their acts. Our data confirms Smith and Brown's observation that, quote, necrophilia may appear as a culmination of a pattern of multiple and increasing perverse practices rather than an isolated, abrupt deviation. And he said, yeah, I agree with that. And when I asked him if he agrees that the use of alcohol or drugs may be an important factor in helping some of the perpetrators overcome their inhibitions and actually perform their necrophilia acts, he says, yeah, I agree with that. And when I asked him that alcohol may be used in some cases to overcome inhibitions about killing rather than about the necrophilia acts, he says, yeah, I agree with that. That's what alcohol is in this case. We'd still be here if he'd never had a drink in his life. Dr. Dietz said, alcohol dependence, mild or moderate, I was looking for that before. Necrophilia, frauderism, impartialism, then he had that spankophilia long word, and his axis 2 was antisocial schizoid or schizotypical personality traits. Now how can someone claim that Dr. Wallstrom is that far different than Dr. Dietz? They can't. They can't. I would like to continue on and tell you about this statement. Certain mental disorders such as mental retardation, schizophrenia, or dementia can have severe effects on functioning. All agree with that. There isn't going to be a psychiatrist in the world that doesn't agree with that. While others, such as sexual deviation, anxiety disorders, and most personality disorders cannot. Footnote, it is possible to concoct improbable factual situations in which these latter disorders, meaning sexual disorders, would form the basis of a legitimate sanity defense. I have never seen such a case and am unconvinced by the cases my psychiatric colleagues offer as examples. You had a man with a mindset, and he had that mindset since January of 1985. That's the fact of the matter. But the one thing I got to say, and I think that the mystery was cleared up, he was always asked this question: did you make an opinion as to whether or not he could appreciate the wrongfulness of his conduct? Did you make an appreciation whether or not he could conform his conduct to requirements of law? Yes, I did. Was it? He could. And I couldn't understand. I'm not hearing this question, what about his mental disease? Now, as you sit there, and as I stand here, I don't know what his answer is, except when I pressed him, he said, that's for the jury to decide. Well, I got to tell you, my people didn't have any problems telling you what their opinion was. And I don't know why I got that answer. You're going to have to make that judgment. It is your decision. So then I pressed him further, and I said, was there such a mental impairment of the mind, whether transitory or enduring, that it affects the mental or emotional processes of Mr. Dahmer? And he says, well, you got to look at the jury instruction. That's up to the jury to decide. And you know why? Because he couldn't say paraphilia was a mental disease. This man had a mindset. It isn't. And he doesn't see anything else. So how could he say it was a mental disease? He couldn't. But his colleague, Dr. Fosdale, said it was. And yet, the guys on his block can beat up the guys on my block. No, they can't. No, they cannot. Because they're split, and mine weren't. And he hired his, and I hired mine. And it sounds to me like what Mr. McCann was saying to you is at the very least, ladies and gentlemen of the jury, don't find that he couldn't conform. Well, I don't care about the first part, but if you don't come up with the first part, you couldn't answer the second part. But remember this, no matter what, he was out of control, so he was able to conform. This is the man who was out of control because he didn't have a car. That's just not fair. Because I can tell you that I could have been in any one of those gay bars with or without a car, and I wouldn't have gotten asked. Because the first thing he wanted was his fantasy. And he wanted to keep his fantasy. So to get his fantasy, certain things had to be in place. It had to be a male. It had to be around the right age, 15 to 25. That male had to have a certain physical structure. There could be no telltale signs that he took the mail back. And because the guy didn't have a car, now he's not a fellow out of control. All of a sudden he doesn't have a mental disease because he's making choices. Well, that's just not the way it works. His choice was clear. He wanted somebody he could keep, kill, and get away with killing so he could retain their body parts and do all his crazy sexual stuff. So because he didn't ever alter from that, the doctors say, aha, this is a man totally in control. That doesn't make any sense. That isn't dispositive of the question. The question is, when he was doing what he's doing, was he sick? And if he was sick, was he still able to say, enough, stop, it's done with? That's the question. And as I say, credible as I can, I don't know if I proved it ever won, but when he got that steamroller going, he was out of control as he was going along with his thought processes when he's letting everybody in the world know that he's bringing this boy back to his apartment, including policemen, and he keeps the parts afterwards and does 3 or 4 more killings. We all are governed by rules of law, and there's things that we're prohibited from saying. The judge told you at the beginning of this case what your function was going to be. You have to make a decision on 15 counts. 15 counts. Whether or not, at the time of the taking of the life of each one of these young men, he was suffering from a mental disease, as he will define it to you as you are entitled to find. If you say no, it's all over. Job done, we all go home, you go home, and you accept your decision. If you say yes to all 15, you will then have to say, even though it's written in appreciate or conform, we're only talking about conformity, was he able to conform his conduct to the requirements of law? If your answer is he was insane but able to conform, it's all over. The judge will sentence him as provided by law. We will have failed. If you say, I think he was insane as to some and could conform as to some, but he was insane as to some and he could not conform as to some because of this mental disease, then the judge's instructions will tell you what will happen to him because he is found insane, and as to those counts that you have found him not insane to or insane of, he will be taken care of as provided by law. He stands convicted of 15 counts of first-degree murder. The rules do not allow me to say more, but your common sense can be utilized in trying to figure out what the total effect of what you do will be. Now, Dr. Frederick Berlin does not need me to stand up here and defend him. When I ask questions of experts, I let them answer. Just me. That's just the way I do it. Because I figure If they start playing games with me, I won't beat them. And if they're being straightforward, I ain't going to beat them. But if I'm doing my job, if I ask them the questions, then I feel you're entitled to know the answers. And if they're going to start playing a little fast shuffle with me, I think I'm skilled enough to cross-examine them to bring them out that they're trying to sell you a package. That's my method. Some people say that's not a good method. I don't care whether it's good or bad. I've been doing it a lot of years, and that's just me. I can't do much about that. But when Dr. Berlin was on the witness stand, the constraints put on him by the questionnaire was answer the question. Answer the question. Now, I brought Dr. Berlin to you as a renowned expert in paraphilia. Renowned. At no time did Dr. Berlin say all necrophiliacs are mentally ill. Not one time did he say that. Not one time did he say all paraphilias are mentally ill. The opposite, he said. But he said this paraphilia was mentally ill. This paraphilia could not conform his conduct to the requirements of the law. That's what he said to you. He said nothing more than that. So anyone who tries to paint him as this big liberal psychiatrist who stands alone on some mountain screaming out that all of these people are okay is not telling the facts, because that's not what he said. And his vitae supports that. If you look at this man who has written 16 articles or appeared 16 times on paraphilia, not only on the invited participant on a White House conference, an invited participant to the United States Senate, an invited participant for the governor of Maryland, an invited participant for the Maryland State Parole Board, an invited speaker for the Connecticut State Department of Corrections. This isn't some wild-eyed liberal psychiatrist who's trying to excuse conduct. The opposite's true. This is a man who wants to help sick people. And my hat's off to him. Dr. Becker, having never testified before, do you realize, ladies and gentlemen of the jury, that there is no doctor who has ever testified on a necrophilic serial killer who has killed 15 men and done what Jeffrey Dahmer has done? No one has ever done that. And I don't care that forensic psychiatrists can come in and tell you what their opinion is. That doesn't impress me. What impresses me is what their experience is. And all of these people were experienced, and 5 of them, 5 out of 7 said mental disease. 5. Now, is there anyone among us that says he doesn't have a mental disease? I think, my opinion, I think even Dr. Dietz is really kind of hedging on it, so he might be 5.5. Dr. Palermo said no, but he didn't find necrophiliac, at least until he testified. He added that. So we got 5, but we only got 3 that said he was so sick that he couldn't conform. And I am not going to repeat my argument over and over again on what those arguments were for that, because I know you heard me. This doctor said neither the legal system nor society needs forensic psychiatrists who believe that an ability to testify qualifies them to answer any question. They need true experts in criminal behavior, mental disability, forensic child psychiatry, or legal aspects of psychiatric practice. That's what Dr. Dietz said in an article that he wrote some years ago, 1987. He holds true to it today, And I submit to you that every gentleman and lady that appeared here fits that bill because they are all experts in criminal behavior and in mental disability. Dr. Dietz graduated from his residency program at the Department of Psychiatry at the Hospital of the University of Pennsylvania, and with great pride, he put down that he became a consultant to the United States Attorney's Office in 1981 on the case of U.S. versus John Hinckley. So Wallstrom, discount. Do you think that Dr. Dietz should have been discounted in that case? I think not. My guess is that the jury heard what he had to say, and they just didn't accept what he had to say. That's the way it's played. I think it's clear. I'm getting towards the end of this. This is the toughest part of the things that I do, is having to look at all these notes. And the only reason I have to is because if I sit down and I never speak to you again, which I won't be able to, and I can't say I should have said that because that will hurt. So I try and say everything I can. I have my associates write everything down. I want to get into this, how come we didn't call anybody? You know, that's always an argument. You know, you could have called somebody and somebody could have told us this. Well, this is a guy that didn't have a relationship with anybody for longer than 10 hours. I mean, I frankly couldn't make opinions about 3/4, 5/7, 6/7 of the people I run across. I mean, the carpet man came in here. The guy who cleaned his carpet came in and he said he didn't have hallucinations or delusions. Well, what is that supposed to mean? And you know, this Tracy Edwards thing seems to be for some way or another a craw in somebody's throat. But I didn't see the detective who took the statement from Tracy Edwards being called here to be asked the questions by the prosecutor. Did you ask him how Dahmer was acting in that bedroom and whether or not he was rocking and chanting? And what difference does it make? None of my doctors said the reason I think he was crazy because Tracy Edwards told me he was rocking and chanting. Nobody relied their opinion on that, but I think it was important for you to know what it was like for that one human being who was present and about to be killed as to what he was acting like, so you could use that for whatever purpose you wanted. And I keep on hearing about this apartment. I mean, there's a lot of locks on that door, but this apartment that's supposed to be so clean doesn't look to me like it's too tidy. Seems to me the pictures they show are a few cans of beer hanging around and paper strewn on the floor and you know, a whole bunch of boxes hanging here. And you know what? How good a killer this guy is, how in control he is? He leaves the shades open. Look at this, those drapes wide open. The officer said that you can look in them. Might be a little tough, but with the lights on, here's a guy that's about to kill somebody that got it open. I don't buy it that this man doesn't show himself to be out of control, therefore he can conform. I don't think that's the test. I think the test is all of these people were killed because of his paraphilitic disorder, and he couldn't have stopped it on willpower alone. That's simple. I really wish I could just sit down and stop talking about all of this, but I can't. But let me try something on you. And maybe I can, you know, I don't know why we insult people who put themselves at risk by standing before the public and taking a position on something like Dr. Berlin's statement. You know, I don't need to see, you know, if a few trees are cut down, we're still in a forest, as being a demeaning statement. I just don't think that's fair. I don't think that's any fairer for me to say, and I'm not saying it because I mean it, but I want to give you an example, that if I was getting $300 an hour, I may want to watch videos with Mr. Dahmer too. I don't think that would be a very classy thing to say, and I wouldn't say it. And I said it only to illustrate a point. I illustrate the point that Dr. Berlin is an absolute expert and that he did not have to sit down and go through each and every item to arrive at his conclusion that when you're stricken with what he has, it doesn't go away. And when I had enough of facts to know that his condition was X, I didn't have to sit down and write the biography of his life. And I don't know why anybody would look askance at a person that made that answer. And if we were going to put on a dog and pony show, we could have had him sitting here for 3 days, so that wouldn't have been argued, but that would have been an insult to his intelligence to force him to do that. And besides that, as Dr. Wallstrom said to you, he had the advantage, as did Dr. Wallstrom, as did Dr. Becker, all of my work product. And I'm the only guy getting the story out of the defendant at the initial stages until he starts talking to the doctors. So how much time does he have to spend? Dr. Palermo knew within 4 hours that he wasn't insane. Dr. Berlin knew in 3 hours and 45 minutes he was. Which one do we accept? Let me ask you a question. Think of yourself with a 15-year-old son. And that son is the most precious thing in your life. Your entire life is around that son. And one day he comes home and he says, Mom and Dad, I got to talk to you. I got a problem. I got a problem because something's happening to me and I don't know what to do about it. And you say, what is it? First thing you know, everything shoots through our mind. He's smoking grass. He's drinking alcohol. He's in trouble at school. He said, no, it's none of those things. It's worse than that. And then you say, well, he had an accident with the car. He's had this, he's had that. And he said, no, here's what's happening to me. I cannot get over these sexual urges that I'm having. Well, I say, everybody has sexual urges, son. Don't worry about it. He said, Mom and Dad, I'm telling you how bad it is. I have these sexual urges that I'm walking around with day and night to want to make love to a dead body. I want to render somebody unconscious and have sex with them, and I can't get it out of my mind. Who are you going to call? Dr. Dietz? Dr. Fosdil? Dr. Friedman? Dr. Wallstrom? Dr. Palermo? Dr. Becker? Or Dr. Berlin? While you're fighting to get the phone, one calling Baltimore and the other one calling Tucson, you want those two because they know what's wrong with your son. And if they were to tell you on the phone, tell me about them. By the way, we're hearing about all these things that Dr. Dietz did. I don't remember him talking to Tracy Edwards. I don't remember him talking to Mr. Dahmer, the father. I don't remember hearing he talked to Mrs. Dahmer, the mother. I don't know where he did some trips, he went to gay bars, he went to the apartment, but I don't hear him doing this totally great job that I'm told that he did the best job. If you remember what my doctor said, Dr. Wallstrom talked to Tracy Edwards. Mr. and Mrs. Dahmer were talked to. We had reports. These guys all did the best possible job they thought they had to do their job in the courtroom, including Dr. Dietz. But my point is, when you call the doctor on the phone and he says to you, how many times a day is your son masturbating? And you say, 2 to 3. And what is his fantasies about? And you say, they're about drugging someone or hitting them over the head and having intercourse of some sort or sex with them while they're in an unconscious or dead state. And then you say, and then the doctor says, well, how long has it been going on? Well, it's been going on for quite a while, he tells us. And what else has he done? Well, he's been messing around getting roadkill off the streets and looking at the insides and getting turned on by that. And they say, well, wait a second. He's okay. This isn't really a mental disease or an illness. Willpower will be able to stop it. You tell him to stop that business, you're going to be on the phone with somebody else. Because you know you got a sicko on your hands. And you see, with all due respect about our normal sex urges, whatever they may be, this is what we have with Jeffrey Dahmer. This is his sexual urges. This is what he's got: the fleshing, lobotomies, murders, graveyards, posed pictures, masturbations, drugging, cannibalism. We're not talking about the same person. There's nobody in the world like him. Nobody. Could he have stopped without, on his own? No. When did it get to the point, if at all? I at least think I'm about to sit down. I got to check with all of my people here to see if I've covered it. When do we get to the point where we say, justice demands that I say, at this point in time, he had a mental disease. There was something mentally wrong. He had an impairment of his mind that affect his mental and emotional processes? Or do I say, it never happened. He never had that impairment of the mind? Of course he did. But he had it at some point in time. And then the next question is, if that's true, when was he unable to stop? When did that impairment become so strong that it affected his capacity substantially to stop? And I submit to you, and I owe this to you, to say that I know I proved that to you as we were getting down the line with the that one gentleman who ended up in the locker, whose skull ended up in the locker. And I'll tell you another time I proved it to you, is in that Conrack situation, in those 4 murders that took place within a month or a month and a half's period. And that would be a mixed verdict. You're entitled to make that. But we all of us have to make sure that the day after we make the decision, whatever it is, just as I'll make the decision tomorrow, when we look in the mirror, did we say we did our job and we did our oath? And see, people don't believe this. I don't care about winning or losing. I just don't care about it. It's just not why I'm here. I am here because I refuse to run from what I'm supposed to be doing, regardless of anybody out in Wonderland that agrees or disagrees. Because someday I'm going to have to answer to the Maker. And he said, amongst other things in the good book, the least you do for one of these, my brethren, you do unto me. If he's evil, he deserves no consideration. He's a maniacal killer. But if he's sick, he should be found to have been sick when his sickness under the law was such that he lost it. And at some time when he was given in to these urges, he lost it. I think I've covered it. Let me check, if you will, with my team. We never heard from, when I'm criticized by the fact that I didn't bring in a whole bevy of people who probably would have made the dumbest gave the dumbest lay opinion in the history of the world. Sir, how long did you know Jeffrey Dahmer? Well, I worked with him for 7 years. Well, how many times did you talk to him? 3 times. Well, did he appear to be out of his mind? Yes, he did. I mean, come on, this guy is the most desolately lonely human being imaginable. And the only time he could get companionship is in the manner and form in which he tried it, creating all these tragedies that he created. I'm going to just talk. One thing I want you to think about. He's a liar. I mean, it would be almost inconceivable to believe that a person who is a paraphilic who wants to have sex with dead bodies is going to be honest. I mean, it just speaks for itself. The thing that causes me the greatest concern is this supposed control that he had. I submit to you that a person who has control is never, ever going to take chances that they're just going to be discovered. And the craziest statement that he ever made was in the confession to the police, where incidentally, once again, I want to reiterate, he never tried to blame it on anybody other than himself, where he said, you know, after I brought Conrack back and I was able to convince those people, that I figured I could get away with it forever. You know how crazy that is? He maintained 10 skulls. We know, as Mr. McCann has even said to you in argument, those folks could have been identified because of their teeth work. So he has the evidence of all of his crimes sitting in his apartment, which he cannot dispense with because of his craziness. He retains them, and after Conrack, he does 3 or 4 more. Now, why wouldn't this very controlled fella say, aha, I got big problems today. I got to start departing of all this, or getting it out of here, or bringing it over to my grandmother's house. All I have to do is go down to the Grand Avenue Mall like I did in the Toomey case, get back here, get those skulls out of here. In case anybody starts looking for that Asian boy, they're going to find no evidence here. It would only take him a couple of days. He doesn't do it at all. And he still does 4 more. And I'm supposed to say on that hypothetical, this is a guy in control of his environment. This is a guy who's so out of control in his environment that the only thing he can do is to plan his next killing, because that's all he ever thought about. And that's tragic, and that's pathetic. I am proud to be here, and I thank you very much for your attention. I don't thank you to patronize you. I thank you because what you're about to do is going to be 10 times tougher than what I have done in here. Because all I was a servant. You're the decision maker, and whatever way it is, it's your decision, and I'll respect it, and I pledge to you I will respect it. Thank you very much.
Well, jurors, now it's going to be my turn for a few minutes, and after that it'll be your turn. Members of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdict. In applying these instructions, keep in mind the following. First, you should consider all of the instructions. Second, you should consider the instructions as a whole and apply them to the evidence. Third, The fact that the instructions are given in a particular order does not mean that one is more important than the other. Take the law as it is given in these instructions and apply that law to the facts in the case, which are properly proven by the evidence. Consider only the evidence received during this trial and the law as given to you by these instructions. And from these alone, guided by your soundest reason and best judgment, reach your verdict. Evidence is three things. First, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received into the trial record. Third, any facts to which the lawyers have agreed or stipulated, or which the court has directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, and I should change that language because the issue here is not guilt or innocence, the issue is responsibility, so let me say whether the defendant is responsible or not responsible, disregard such impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. Count one of the information in this case charges that the defendant, Jeffrey L. Dahmer, in January of 1988 at 2357 South 57th Street, City of West Dallas, County of Milwaukee, did cause the death of another human being, James E. Dockstader, with intent to kill that person contrary to Wisconsin Statute Section 940.01. Count two of the information in this case charges that the defendant, Jeffrey L. Dahmer, in March of 1988 at 2357 South 57th Street in the City of West Dallas, County of Milwaukee, did cause the death of another human being, Richard Guerrero, with intent to kill that person contrary to Wisconsin Statutes Section 940.01. Count three of the information in this case charges that the defendant, Jeffrey L. Dahmer, on or about March 26, 1989 at 2357 South 57th Street, City of West Dallas, County of Milwaukee, did cause the death of another human being, Anthony Sears, with intent to kill that person contrary to Wisconsin Statute Section 940.01, Paren 1. Count four of the information in this case charges that the defendant, Jeffrey L. Dahmer, during the spring or early summer of 1990 at 924 North 25th Street, City and County of Milwaukee, did cause the death of another human being, Raymond Smith, also known as Ricky Beeks, with intent to kill that person contrary to Wisconsin Statute Section 940.01, Paren 1. Count five of the information in this case charges that the defendant, Jeffrey L. Dahmer, during the summer of 1990 at 924 North 25th Street, City and County of Milwaukee, did cause the death of another human being, Edward W. Smith, with intent to kill that person contrary to Wisconsin Statute Section 940.01, Paren 1. Count six of the information in this case charges that the defendant, Jeffrey L. Dahmer, on or about September 3rd, 1990, at 924 North 25th Street, City and County of Milwaukee, did cause the death of another human being, Ernest Miller, with intent to kill that person contrary to Wisconsin Statute Section 940.01, Paren 1. Count seven of the information in this case charges that the defendant, Jeffrey L. Dahmer, on or about September 24th, 1990, at 924 North 25th Street, City and County of Milwaukee, did cause the death of another human being, David Thomas, with intent to kill that person contrary to Wisconsin Statute Section 940.01, Paren 1. Count eight of the information in this case charges that the defendant, Jeffrey L. Dahmer, on or about February 18th, 1991, at 924 North 25th Street, City and County of Milwaukee, did cause the death of another human being, Curtis Strouter, with intent to kill that person, contrary to Wisconsin Statute Section 940.01, Pren 1. Count 9 of the information in this case charges that the defendant Jeffrey L. Dahmer on or about April 7th, 1991, at 924 North 25th Street, City and County of Milwaukee, did cause the death of another human being, Errol Lindsay, with intent to kill that person contrary to Wisconsin Statute Section 940.01, Pren 1. Count 10 of the information in this case charges that the defendant Jeffrey L. Dahmer, on or about May 24, 1991, at 924 North 25th Street, City and County of Milwaukee, did cause the death of another human being, Tony Anthony Hughes, with intent to kill that person contrary to Wisconsin Statute Section 940.01, Pren 1. Count 11 of the information in this case charges that the defendant Jeffrey L. Dahmer, on or about May 27, 1991, at 924 North 25th Street, City and County of Milwaukee, did cause the death of another human being, Conorak Synthesymphone, with intent to kill that person contrary to Wisconsin Statute Section 940.01, Pren 1. Count 12 of the information in this case charges that the defendant, Jeffrey L. Dahmer, on or about June 30th, 1991, at 924 North 25th Street, City and County of Milwaukee, did cause the death of another human being, Matt Turner, also known as Donald Montrell, with intent to kill that person contrary to Wisconsin Statute Section 940.01, Pren 1. Count 13 of the information in this case charges that the defendant Jeffrey L. Dahmer, on or about July 7th, 1991, at 924 North 25th Street, City and County of Milwaukee, did cause the death of another human being, Jeremiah Weinberger, with the intent to kill that person contrary to Wisconsin Statutes Section 940.01, Pren 1. Count 14 of the information in this case charges that the defendant Jeffrey L. Dahmer, on or about July 15, 1991, at 924 North 25th Street, City and County of Milwaukee, did cause the death of another human being, Oliver Lacey, with intent to kill that person contrary to Wisconsin Statutes Section 940.01, Pren 1. Count 15 of the information in this case charges that the defendant Jeffrey L. Dahmer, on or about July 19, 1991, at 924 North 25th Street, City and County of Milwaukee, did cause the death of another human being, Joseph Bredehoff, with the intent to kill that person contrary to Wisconsin Statute Section 940.01, Pren 1. The defendant Jeffrey Dahmer has been found guilty of every count in the information. You have just heard testimony about the defendant's mental condition at the time of the offense. You will now be asked to determine whether the defendant is responsible for his criminal conduct. Before you may find that the defendant is not responsible for his criminal conduct, the defendant must satisfy you to a reasonable certainty by the greater weight of the credible evidence that at the time the crime was committed, he had a mental disease, as a result of which he lacked substantial capacity either to appreciate the wrongfulness of his conduct or to conform his conduct to the requirements of law. This issue will be presented to you in the form of 2 questions. Now, actually, what you're going to receive is 15 different verdict forms. 1 verdict form as to each count in the information. And I'm going to read what those questions are as to one of the verdicts. I don't think we have to go through all 15. I suspect we've had enough repetition throughout this case. Question 1 will read, at the time the crime was committed in count 1 of the information, in regard to the death of James E. Dockstader, did the defendant Jeffrey L. Dahmer have a mental disease? And then there'll be a space for an answer, which will be either yes or no. Question number 2. If you have answered question number 1 yes, then answer this question. As a result of the mental disease, as to count 1 in the information, did the defendant lack substantial capacity either to appreciate the wrongfulness of his conduct or to conform his conduct to the requirements of law? And again, there's a space for an answer, which will be either yes or no. Now, the first question is, at the time the crime was committed, did the defendant have a mental disease? If you answer the first question yes, you will be asked to answer the second question, which is, as a result of the mental disease, did the defendant lack substantial capacity either to appreciate the wrongfulness of his conduct or conform his conduct to the requirements of law? The first question is, at the time the crime was committed, did the defendant have a mental disease? Mental disease is an abnormal condition of the mind which substantially affects mental or emotional processes. You are not bound by medical labels, definitions, or conclusions as to what is or is not a mental disease. You should not find that a person is suffering from a mental disease merely because he may have committed a criminal act or because of the unnaturalness or enormity of such act, or because a motive for such act may be lacking. Temporary passion or frenzy prompted by revenge, hatred, jealousy, envy, or the like does not constitute a mental disease. An abnormality manifested only by repeated criminal or otherwise antisocial conduct does not constitute a mental disease. A voluntarily induced state of intoxication by drugs or alcohol, or both, does not constitute a mental disease. A temporary mental state, which is brought into existence by the voluntary taking of drugs or alcohol, does not constitute mental disease. Chronic use of drugs or alcohol may produce a condition that can constitute a mental disease if the condition has become permanent. If you are satisfied to a reasonable certainty by the greater weight of the credible evidence that the defendant had a mental disease at the time the offense was committed, you must answer the first question yes, and go on to answer the second question. If you are not so satisfied, you should answer the first question no, and you need not consider the second question. The second question is, as a result of the mental disease, did the defendant lack substantial capacity either to appreciate the wrongfulness of his conduct or conform his conduct to the requirements of law? Before you may answer this question yes, you must be satisfied that the defendant's mental disease caused a substantial impairment in his capacity to understand what he was doing was wrong or to conform his conduct to the requirements of law. If you are satisfied to a reasonable certainty by the greater weight of the credible evidence that as a result of the mental disease at the time of the offense was committed, the defendant lacked substantial capacity either to appreciate the wrongfulness of his conduct or to conform his conduct to the requirements of law, you must answer the second question yes. If you are not so satisfied, you should answer the question no. If you answer both of these questions yes, the defendant will be found to be not responsible for the offense, and you will be committed to the Department of Health and Social Services and will be placed in an appropriate institution unless the court determines that the defendant would not pose a danger to himself or to others if released under conditions ordered by the court. In deciding whether the defendant is responsible for the criminal conduct, You are to consider only the issue of the defendant's mental condition at the time of the offense committed. Agreement by 10 or more jurors is sufficient to become the verdict of the jury. Jurors have a duty to consult with one another, to deliberate for the purpose of reaching agreement. If you can do so consistently with your duty as a juror, at least the same 10 jurors should concur in all of the answers made on each verdict. I ask you to try to be unanimous if you can. Now, you will find space at the foot of the verdict where dissenting jurors, if there be any, will sign their names and state the answer or answers with which they do not agree. Either the blank lines or the space below may be used for that purpose. Disregard entirely any question the court did not allow to be answered. Do not guess what the witness's answer to such question might have been. If the question implied that certain facts were true, disregard any such implication and draw no inference from the question. During the trial, the court has ordered certain testimony to be stricken. Disregard all stricken testimony. Remarks of the attorneys are not evidence. If the remarks implied that the existence of certain facts not in evidence, disregard any such implication and draw no inference from the remarks. Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions and your own inferences from the evidence and decide upon your verdict according to the evidence under the instructions given you by the court. The district attorney and the attorney for the defendant have stipulated or agreed to the existence of certain facts, and you must accept these facts as conclusively proved. The weight of evidence is not to be decided merely according to the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than that of another witness, or even several other witnesses, and you may give it such weight in considering your verdict. In weighing the evidence, you may take into account matters of your common knowledge and your observation and experience in the affairs of life. The general rule is that witnesses may testify only to facts they know. A witness, however, who has a special knowledge, experience, skill, training, or education in a particular profession or occupation is permitted to give an opinion as an expert in the field. In determining the weight to be given to the opinion of an expert, you should consider the qualifications and credibility of the expert, whether the opinion is based upon established facts or agreed facts in the case, and the reasons given for the opinion. Such evidence is received for the purpose of aiding you in arriving at a conclusion if it does so aid you. You are not bound by the opinion of any expert. You should consider carefully the opinion evidence with all the other evidence in the case, giving to it just such weight as you decide it is entitled to receive. In resolving any conflict that may exist in the testimony of expert witnesses, you should weigh the opinion of one expert against the other. In doing this, you should consider the relative qualifications and credibility of the expert witnesses, as well as the reasons for each opinion and the facts and other matters upon which it is based. The court has appointed Dr. George Palermo as an expert witness. The same tests as are applied to all other witnesses' testimony are applicable to the expert appointed by the court. Each party has the privilege of calling other experts at the trial. During the trial, an expert witness was told to assume certain facts and asked for an opinion based upon that assumption. This is called a hypothetical question. Consider the opinion only if you believe the assumed facts upon which it is based. If you find that the facts stated in the hypothetical question have not been proved, then the opinion based on those facts is not to be given any weight. The general rule is that witnesses may testify only to facts known to them. There are exceptions to this rule, And in this case, several witnesses were allowed to give an opinion as to Jeffrey Dahmer's mental condition at the time they had contact with him. In determining the weight to be given to this opinion, you should consider the witness's opportunity to observe what happened and the extent to which the opinion is based upon that observation. The opinion is received for the purpose of aiding you in arriving at a conclusion if it does aid you. You are not bound by the opinion of any witness. You should consider carefully the opinion evidence with all the other evidence in the case, giving to it just such weight as you decide it is entitled to receive. Attorneys for each side have the right and duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. No adverse inference is to be drawn from any such objection. By allowing testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion as to the weight of the evidence. You jurors are the judges of the credibility of the witnesses and of the weight of the evidence. It is the duty of the jury to scrutinize and weigh the testimony of the witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility of the several witnesses and of the weight and credit to be given to their testimony. In determining the weight and credit you should give to the testimony of each witness, you should consider their interest or lack of interest in the result of this trial, their conduct, appearance, and demeanor on the witness stand, their bias or prejudice, if any, has been shown, the clearness or lack of clearness of their recollections, their opportunity for observing and knowing the matters and things testified to by them, and the reasonableness of their testimony. You should also take into consideration the apparent intelligence of each witness, the possible motives for falsifying, and all other facts and circumstances appearing on the trial which tend either to support or discredit their testimony, and then give to the testimony of each witness such weight and credit as you believe it fairly entitled to receive. Now, members of the jury, this case is ready to be submitted to you for your serious deliberation. You will consider the case fairly, honestly, impartially, and in the light of reason and common sense. Give each question in the verdict your careful and conscientious consideration. In answering each question, free your minds of all feelings of sympathy, bias, or prejudice. Let your verdict speak the truth, whatever the truth may be. When you retire to the jury room, your first duty will be to elect a juror who will preside over your deliberations and write in the answers you have agreed upon. The vote of the presiding juror, however, is entitled to no greater weight than the vote of any other juror. When your deliberations are concluded and your answers inserted in the verdict, the presiding juror will sign and date the verdict, and all of you will return with the verdict into court. The clerk will now swear the bailiffs. Sure.
You do swear that unless otherwise ordered by the court, you will not want to call jurors one of this trial together in some highly convenient place. You will not suffer any person to speak to them or speak to them yourself until they have agreed on their verdict or discharged by the court. That you will not, before they render their verdict, communicate to any person who stated their deliberations or the verdict you have agreed upon shall be done.
I do. I would instruct the bailiffs that the jury is not to commence its deliberations until we have gone through the procedure of determining who the alternates are, which we will do in just a moment. However, the